I'm not mentioning, but it's a restoration application with a section 5.
My lord, may I, my lordship, can leave to
Restoration
redaction of item 282 of
Please
the.
mention the urgency and over the
My lord, an old man, his land has been taken away. 21.
Indicate that.
My lord, I have.
Please hand over.
and may be permitted to mention for inclusion in the list, my lord.
That-
Under the it was appearing under the heading adjourned motion before the honorable coordinate bench.
hand over this. Yes, call the list.
Number 1.
Lordship, for the petitioner, Your Lordship.
Yes.
The correction was there, Your Lordship. The third last paragraph, the WPA number is written as 33 instead of 29019.
It has been. Yes.
For the Act to 1948 proceeding, when a proceeding has been lapsed,
Proceeding lapse.
proceeding lapsed. Well, kindly come to page 37 is a complaint.
Complaint. What complaint?
Complaint written to the, my lord, the SLO.
Yes, Mr. Kali. What is the instruction?
My lord, so far as paragraph, my lord, 16, page 12 of the writ petition is concerned, I need the update. He says that be it noted, be in the instant case, in spite of issuance of notice under section 9(3)(b) on 19 September 2000, no award has been passed till date. I'll have to take update on this. And secondly, Lordship, may I ask this question to myself? That 1948 Act 2 proceeding lapsed. My lord, where from does it appear, my lord? That lapse upon.
If you have not declared the award.
But
within the
1990, Lordship, Act 2 of 1948, it was till 31st March 1997. Thereafter, by Act of 1990, it was extended.
By Act of
1996, it was extended.
it was
By
not-
insertion.
not automatically extended. You
Lordship.
could have invoked 9(3)(a) or 9(3)(b) as the
3B,
case may be.
9(3)(a), 3B. So
So
9(3) and
here it's the
3B.
positive case that the 9(3)(b) was invoked. So once you invoke 9(3)(b), you are required to publish the award.
Now, my lord, question of lapse. This concept, my lord, don't take me in the amaze, because I was examining also, and one argument was also going yesterday before Court 16. Lapse is the word which is found in section 11 of Act 1 of 1894. But by Act of 1997, a proviso has been added to section 11 of 1894. That in case of those proceedings which were under Act 2, that proviso is applicable. 11 original part is not applicable, proviso is applicable. So 11 original part is telling lapse, but proviso never said is lapsed, because, my lord, 1948 Act, it goes by efflux of time. It is not a repealed act. It is a temporary act for a particular period of time. By efflux of time, it went out.
Yes.
But those proceedings which were initiated, but there was some anomalies with regard to whether notice was issued under section 41A or not, whether award was made under section 7, subsection 2 within 3 years from the date of notification of section 41A or not. All these things, my lord, were taken care of by inserting, my lord, section 3A and B in the Principal Act.
Act 2 of 48 to be of the Act, Mr. Gali.
Lordship. I have the West Bengal laws version.
Yes.
And this is 1997. This is section 11A of LA Act Act 1, Lordship. Act 1, Lordship has.
Act 1 I have.
Lordship.
This is section 7A.
Yes. Shall make an award under subsection 2 of 7 within a period of 3 years from date of publication of notice under section 41A. And if such award is not made within the period as aforesaid, the said notice shall lapse. So 41A,
So 41A is the
Lordship.
acquisition. Unless you invoke 41A,
there is no
Only
vesting.
requisition.
There is no vesting.
it's only requisition.
Lordship. Lordship.
So if 41A, no award has been passed within 3 years, in view of 7A, notice lapses.
This lapse
If the
part.
notice lapses, the acquisition proceedings also.
My lord,
lapse.
this concept, my lord, I have come across one division bench judgment 2025 delivered by my lord Justice Shobhoshi Bhattacharya and Honorable Justice Uday Kumar, 2025 SCC Online Cal 7863. But my lord, after the efflux of time or expiry, which the Honorable Supreme Court in one of the judgments says is a defunct act, 1948. Defunct act, it says in one of the judgments. But my lord, kindly, my lord,
Mr. Kali, when 41A was issued?
here factual aspect is, my lord, I have not gone because I have to take instruction on this.
If 41A, within 3 years, during the validity period of the act, if award is not passed, notice lapses, meaning thereby the proceedings lapses.
No, my lord, my
Second is, after the lifetime of the act, can you invoke the provisions of a lapsed act?
but there, my lord, my reciprocal in
For that,
Lordship.
9.3a and 9.3b has been provided. You have to continue that with 9.3b. Here is a specific averment that 9.3b has been invoked.
lordship.
So you have sought to acquire. So if 9.3b within the specified time limit, also award is not passed, that proceedings also lapses. Please file a report with regard to this. What happened?
On factual aspect, I will, my lord, but my lord, in
Then,
respectful reply,
Unless
my
the
lord,
facts come,
lordship.
law cannot be applied to those.
Lordship, lordship, my lord, but my lord, lordship may kindly allow me, my lord, to argue on this point, my lord. I will bring the judgments also, my lord.
Will be
And
argued.
lapsation,
Let the facts.
yes, lapsation, that lapsation part, my
There
lord,
should not be any dispute on facts.
lordship,
Facts.
lordship,
Let the
lordship.
facts come.
Because,
Thereafter,
my lord,
you will be free to
we are lordship,
you'll be
because
free to make arguments, because the special bench judgments are also there.
lordship, lordship, lordship,
You are aware
lordship,
of those
lordships,
special bench
lordships.
judgments are also there. And I have also delivered a judgment considering all those.
Lordship,
You can consider all those judgments
Lordship.
also, and
Lordship.
I will allow you to make all submissions on factual as well as legal points.
Lordships.
Ashun.
In for the petitioner.
Yes.
My lord, I'm appearing for the
Please,
respondent, private respondent, my lord.
Lordship, the
It is of the judges library, lordship. Eta. Great.
My lord, I am appearing for the private respondents, my lord. Actually, my lord, Miss, I'm led by Miss Shomakar Ghosh, my lord. Actually, she is suffering from pneumonia. That's why I'm seeking adjournment only for 21st. my lord.
for representation has been made before the authority concerned Lordship. Annexer P3 page 30, 1964 Highway Act.
So today only I have received.
Only to
I'm directing them to consider.
consider, you would not be effective.
Lordship.
But an inquiry
Not
by
only
the
that, my lord.
BRO.
I have already received permission from the panchayat also. So that is what.
taken into consideration by the authority.
What other licenses you have got from which authority?
Take that
Panchayat,
point
you have
there.
got permission? Any other authority? WBSEDCL connection, electric connection? You are
Electric
having?
connection is there.
Yes. What more trade license you are
Yes,
having?
yes. Trade license is also.
Any other licenses, permission from any other authority?
Yes, my lord.
Yes. Ashun, the petitioner
Service has been complete, my lord. Matter is relates to the, my lord, encroachment of PWD land adjacent to the petitioner land. I have made representation that is not considered. This is the affidavit of service.
Yes, Mr. Bandyopadhyay, what do you say?
My representation is page 20, my lord.
Let a decision be taken by the authority concerned. Assistant engineer PWD. If it is the, my lord, the land of the petition. If any encroachment is there on.
Which is your property?
My lord, my property is
Plot
number
28665.
5, yes, my lord. East side of the
The petitioner claims
Please verify service. As our the respondent.
yes.
The contention of the petition is that the executive engineer admitted the fact there was one-time repair and work at the behest of the petitioner's record, which is at page 42 and it's a P9. Land was acquired without acquisition for construction of road. Till date, no acquisition notice anything, but no compensation has been disbursed in favor of.
Lord, your lordship, kindly come to page 40. Order of Justice Shubhra Ghosh.
14.
No, 40.
40.
40. 39. It starts from page 39.
Yes.
Order dated 21st February 2022 in WP number such and such. Your lordship, kindly see our lordship leadership directed the petition disposed of the 7th respondent, consider the disposed of the representation by the petitioner on 11 January such and such. The
Yes.
petitioner made a representation. Petitioner says that your lordship, kindly come to page 43 of his representation.
Yes.
Representation, Lord. This land has to be done by the Sundarban Development Affairs department. That is respondent number 11 and 12. So let the representation be considered by the Sundarban Development Corporation, 11 number 11.
Who is
And-
appearing? Who is representing that authority? You are
I am
representing.
representing all. Let the Sundar respondent number 11 and
Property
12.
has been utilized.
No, as per para 5, it is a Kacha road.
Let them
Your
see.
lordship kindly see no
Para
construction.
5 of the
Read petition. It starts from para 5.
Page 5.
Para 5, page 5, your petitioner states that he suddenly came to know from reliable source that the concerned Gram Panchayat sanction a plan of very soon they will construct a public road over the plot of land of the land of the petitioner. After the petitioner heard the information, she immediately went to the office of the concerned Panchayat, Gram Panchayat, and asked whether the road will construct over the plot of land. But the concerned authority of the Gram Panchayat unable to give any answer to the petitioner.
according to you, the executive engineer department of Sundarban Affairs is
Sundarban,
the appropriate
if at
authority.
all it is
So
anything.
you are
is done-
representing him.
Yes, I am all the state
All
responsible.
right. So file a report. Ashun. The petitioner alleges that the
May I,
property.
may I let the representation be considered? That will be better.
Acquisition without any proceedings. Please file a report. No use.
Your lordship
Earlier,
kindly
there
come
was
to,
a direction to consider.
Lord, your lordship kindly comes.
No, the
Kacha road.
decision which you will be taking after the consideration of the representation, that decision will be
Your
now.
lordship kindly appreciate,
So
come
it
to.
will be it will reach a
His
finality.
paragraph won't ever mean, say Kancha road. If any road is constructed
in
by
the-
government,
State that in
proper
the report.
acquisition has to be done. Your lordship knows better than me, Lord.
State that in the form of a report,
That is
then
fine.
nothing remains in the writ petition.
My lord.
The petitioner alleges.
পুলিশের রিপোর্টটা দেবো পুলিশের রিপোর্টে কোনো কাজ নেই
তো নেই তো পুলিশ I am appearing on behalf of the Union of India.
Yes, yes.
You have for the petitioner.
Yes.
In and upon the land of the petitioner, my lord, the railways have laid optical fiber and certain pillars have been erected. Initially, my lord, my father took out two separate RTI applications before the state authority, the Special Land Acquisition Collector, and also the railways.
One thing, yesterday I have received this brief, my lord. I shall take instruction. In the meantime, my lord, kindly see page 16. Page 16.
Yes.
Kindly see সুশীল হালদার সত্য রায়ত মন্তব্য বিজ্ঞাপিত সেচ এলাকাভুক্ত next page also my lord can see same is notified as the irrigation department.
All right. You take instructions. The learned advocate appearing for the Yes. Yes, who is for the petitioner?
Lordship, I'm appearing virtually, Your Lordship. I'm for the petitioner, Your Lordship.
Here the my lord, the
Lordship, I'm
already
appearing for the
assistant
petitioner.
engineer Kontai Highway Subdivision passed the order that the land is not
Lordship,
under the control
I'm
of
appearing-
the highway
Lordship, I'm
authority
appearing
or
for the petitioner, Your Lordship.
Passed an order.
has passed an order. Page 27.
Lordship, I'm appearing for the petitioner, Your Lordship.
So beyond the jurisdiction of the Highways Act.
Highways Act.
Lordship, I'm appearing for the petitioner, Your Lordship.
Yes.
Lordship, kindly comes to page 27.
Yes.
Page 27, the reasoned order. This order was passed pursuant to the direction of a coordinate bench of this honorable court. Your Lordship would find it at page. Lordship, kindly comes to page 24 first, Your Lordship.
Yes.
First round of litigation. Page 24, para 1 and 2, Your Lordship. Respondent number 6 was directed here in this writ petition, Assistant Engineer Kontai Subdivision. He's the respondent number 6. He was directed to consider the matter and to pass a reasoned order, Your Lordship. Now
Yes.
that reasoned order passed by respondent number 6, Your Lordship would find it at page 27, Your Lordship.
Yes.
Relevant paragraph, Your Lordship, para 4, 5, and 6.
Yes.
Now, after seeing the demarcation report and from the record of rights, the respondent number 6 came to the conclusion that it belongs to Jila Parishad, collector, recorded in the name of collector. Your Lordship, the fact is the Agra Solpatta State Highway, it is being maintained and controlled by none other than the respondent number 6, Your Lordship.
No, it's not a highway. That's their decision. It's on Noyanjuli, not on highway.
Lordship, kindly takes the West Bengal Highways Act for a once, Your Lordship.
Yes, Noyanjuli is included in highway.
No.
Noyanjali is included in highway.
Lordship, it is erroneously showing in the record as Noyanjali, but the fact is the plot of land in question,
Then
it is adjacent to the state highway, Your Lordship.
Already file a report.
well, in this matter, my lord, already decision has already been taken. Then what report what shall I improve?
He says that
It is Noyanjali. It is
wrongly classified. You have only went.
if it is wrongly classified, he has to take steps that record of rights. If it is how the my lord, this can be adjudicated, and already the findings of the assistant engineer is
What
there.
documents have been produced to show that it's a highway?
Lordship, my averment is it is being maintained and controlled by the
And
highway
that has
authority.
been denied by the authority.
No, it is nowhere denied. It is nowhere denied that it is not being controlled and maintained by the highway authority.
Petitioner
Assistant engineer.
let a report in the assistant engineer has passed this order.
Then my lord,
Let the block land and land reforms officer file a report.
my lord.
Let the Three,
Lordship,
four. The concerned block land and Negra has reported that the private,
oh, sketch map, the demarcation was also made.
yes,
yes,
everything has
demarcation
been
was-
done. This,
Lordship, with greatest of respect,
My lord,
You have to address that issue.
my
The
lord,
appropriate authority.
approve,
You are the state.
my lord,
You are not the assistant engineer. You are not the.
my lord.
So you are the state. It has come to your knowledge.
Yes,
So it's your duty when one authority finds
yes,
it's beyond his jurisdiction, he has to forward it to the appropriate authority.
my lord.
Yes, next.
Deeply.
This is one of those matters in which land was acquired for embankment and compensation was not given.
Yes. One of those matters, this matter was not taken up.
This matter was not taken up.
Similar matters were taken up.
Similar matters were taken up. Report was called for in all those.
Yes, reports filed in those matters.
Well, that has not yet appeared. The
When
returnable
those matters are scheduled to appear.
I think it was 28. No.
28th of January.
Item number 38 is also there today. One of those matters.
Item number 38.
38 is also.
Yes,
one of
Mr. Bandyopadhyay, have you prepared the report in 38? You are, Mr. Bandyopadhyay is appearing.
Yes, my lord.
You are appearing. So report is ready.
My lord, I don't know, my lord. I have not seen the brief as yet. I have not seen the brief as yet.
Then
I'm sorry, not 38, 30, my lord. I'm sorry.
30.
30, my lord.
Mr. Bandyopadhyay, you are appearing in 30.
030, my lord. Yes, my lord. Yes.
30 you are appearing. So he says in that matter, if it falls within the same Mauja.
I don't know, my lord, what is the contention of that matter, my lord.
Then I can direct this matter to be taken up. Along with that, you can file a report. Comprehensive report can be filed. That can cover. Then you
Well,
don't have
in
to
this
file.
case, my lord, the two petitioners.
You have got instructions in this matter.
No.
Yes.
Only allegation, my lord, his land, my lord, the ring bath has been constructed on his land. No case number, no case, nothing. 38 report is Oh, but 38 report has been come.
Item number 30. What is the report?
30.
Please look at that.
The petition from the available, it is found the plots mentioned in the writ petition of the Mauja such and such. They are another one Mauja, Nafarganj, Basanti.
This is
Not
which
involved
Mauja?
in LA proceedings.
This is Mauja Budokhali, my lord. Budokhali.
Budokhali. Which Mauja is involved there?
It is a Nafarganj.
Different Mauja.
Different Mauja.
Then you file a
PVS is also different.
Then you file
Basanti here is it is 38.
the petitioner much court fee you have paid?
Do not pay court fee. I'm instructed by my advocate on record that court fee in respect of both the petitioners have been paid. That is
দেখে নিন তো কত টাকার কোর্ট ফি
দেখে নিলে দেখলেই তো হয়ে যাবে এটা চেক করে দিন চেক করলেই হয়ে যাবে
Oh, because one has been paid. I've just been said.
আরেকটা দিয়ে দাও
I'll pay. I undertake to pay it in the course of the day.
Mr.
Immediately it will be paid. Immediately it will be.
First pay, then recover.
That's all.
Don't wait for that.
It has to be paid.
Yes.
The petitioner, aggrieved by page 27, annexure P3, where the petitioner's predecessor in interest property has been page 27 has been declared wrongly as enemy property, though the petitioner's predecessor in interest was all along an Indian citizen, my lord.
He is appearing for the Union of India, my lord. He is out of station.
Who is appearing?
Mr. Dheeraj Trivedi.
Where is Mr. Trivedi?
He is out of station, my lord.
Out of station?
Yes, my lord.
Ration
Kindly make
card
it
and
not today.
certificate are annexed,
Monday he will be available, my lord.
Indian citizen. Ration card and
So you are challenging an order?
yes, my lord.
Where is the order?
Page 27, my lord. Where the predecessor in interest of the petitioner's property has been declared as enemy property, holding that she was an Pakistani national.
It's an order of 2016.
But my lord, I came to know that fact, my lord, only in 12th of June 2024 under an RTI reply, my lord.
My lord, file the report.
Thereafter, I have filed a
There is a provision. There is provision.
Appeal.
When the order is.
no, not appeal, my lord, challenging this or disorder, my lord. There is an representation made on made by the grandson of the predecessor in interest, my lord, on 24th of December 2024. That is still pending. That is at page 43, annexure P13. I'm only praying for consideration and disposal of this representation, my lord, which in effect challenging
How
that
can
order.
it be disposed of when an order has been passed?
No, my lord, challenging this order, my lord, this representation has been made. I'll come to page 43, annexure P31, P13.
Please see, there is a provision in section 18.
Yes, my lord, section 18, this is the application under section 18, my lord.
Application, no, we have to prefer a appeal.
Till before the High Court, my lord, after passing that order.
Yes.
Yes.
You have skipped one forum.
My lord, section 18 calls for the challenging that order.
This requires an adjudication on facts.
Yes, my lord.
So that cannot be done under Article 226. You approach the appellate authority.
The provision,
Authority is High Court, my lord, and the
No, section 18.
Section 18 order can be challenged before the state central government, my lord.
Yes.
That is page 43, my lord.
Page
43. P13.
Oh, that order has been also passed. So you have not said that.
No, that order, my lord, representation is pending till date.
No, this is the representation.
Yes, my lord.
Oh, this representation you want decision.
Disposal, yes, my lord. Disposal of this representation by the central government, and if I lose, my lord, thereafter.
Custodian of. All right, come at Monday. He will be available, Mr. Trivedi.
Yes, my lord.
All right. An accommodation has been sought for on the ground of Mr. Trivedi, Honored Deputy Solicitor General of India. First up, HON'BLE Honored Advocate for the petition and Mr. Dale, Honored Additional Government Pleader for the state. First up, on the prayer of on the prayer made on behalf of Mr. Trivedi, list this matter. Monday, date দিয়ে দেবেন under the same heading. Next.
Yeah.
Yes, call the next matter.
My lord, I am for the petitioner.
I appear for the union of it.
My lord, pursuant to the order passed by this honorable court, my lord, my application for compensation was referred to the arbitrators in view of section 23A of the Railway Act. My lord, arbitrator passed the order. Challenging that order, my lord, came before your lordship only on the point that my lord was pleased to satisfy that 149 that I was not present at the time of hearing. So, my lord.
Yes, madam, what is the instance?
Lordship, your lordship had asked me to check with the railway authorities if the arbitrator can be appointed again and if the whole proceeding can be conducted again.
Present, admittedly they were.
Yes, your lordship. So, your lordship, I consulted with them. I, in fact, went to the GM Railway, Eastern Railway's office, your lordship. We had a discussion over this. And your lordship, he said to me that this will set a very wrong precedent because if we allow it once, because the notice was served, your lordship. And he said most of these arbitrations are now taking place online. So, your lordship, he said there's nothing that we can do because lot of logistical costs are involved, lot of procedural costs are involved because once an arbitrator is appointed, there's an entire process, your lordship, that goes on behind this, your lordship. So, your lordship, he has requested me to kindly submit before your lordship to kindly not allow this since the notice had already been served.
For a moment, let's page.
Who are you?
For the state, though I am appearing for the state, but kindly see the order, my lord.
Yes.
Notice are duly served and service return are filed with the case record. Then case is taken up today for hearing in online mode. The petitioner Sri Ambia Mondol is not present and absent on call. But next paragraph, heard the parties.
Heard the parties who are present. Petitioner was not present.
Heard the parties. Parties means
No.
And
please see, the Taposh Mondo Special LAO Bankura is present on behalf of such and such. So,
heard the parties.
Because no. Then there is a contradiction in the order. Then there's a contradiction in the order. First line says he was not. He was absent.
And order was passed against the order, Miller. There is a provision for appeal, Miller.
Also, your lordship, my instructions are to submit that as far as the amount of compensation is concerned, it is determined by the competent authority of the state government, your lordship. The railways only provides the fund to the state authority for disbursement of compensation to the land.
Order passed by whom?
Order passed by
arbitrator.
By the arbitrator, your lordship.
Who is the arbitrator?
Commissioner Medinipur Division.
Appointed
Yes,
by,
yes,
appointed by central government.
Yes.
But Commissioner Medinipur Division you are representing.
Yes.
But appointed by central government.
Yes, your lordship is.
For whom you are representing? Appointed by the central government. But you are representing now.
But Miller, the order,
officer of the state. So he has been appointed. Yes, sir. What is your submission?
My lord, online mode, my lord, due, my lord, no, online mode, my lord, due to
File section 34.
My lord,
That's the provision. I've
my
told
lord,
you
my
on the
lord,
last
my
occasion.
lord, last occasion I
34
yes,
also there is a ground.
my lord, that is time, but first, my lord, I stated earlier occasion. My lord,
Very recent decision.
Yes, lordship.
If you have approached the writ court after expiry of the period of limitation, that cannot be a ground.
Lordship, last occasion I submitted one judgment before your lordship, paragraph 54 onwards. My lordship was satisfied with that, my lord, and directed them.
Satisfied? Then give me.
Lordship, 55 reported in 2025 for SCC 1. Lordship, got it?
No, I've got that. Yes. Which paragraph?
54, 55.
54
and 55.
No, this is, I think, on a contractual, in the contractual field where the contract contains an arbitration clause. The issue arose whether the party should be relegated to arbitration or 226. On those facts, it was held, no, the party may not be relegated, 226 is maintainable. But here is a case where the arbitrator has passed an award. So when an arbitrator has passed an award and the Arbitration and Conciliation Act provides for a remedy under that act, whether 226 can be entertained. So those line of decisions where the Supreme Court has deprecated, has said you have to approach that after the final order has been passed.
May I submit one thing, Lordship? Anything,
Those are also Supreme Court.
May I submit one thing? In case of violation of principle of natural justice, writ is maintainable. In an online mode, may I submit one thing? Kindly visualize the fact. In an online mode,
When the award was passed by the arbitrator?
But it was passed on April 21, but my lord, it was communicated.
April 21, and when you have filed?
April 2025, 21 April 2025, award was passed. It was communicated to through Land Acquisition Block Development Officer on 28/7/2025.
28th of July 2025.
Yes.
When you have filed this writ petition?
It was filed. I filed the writ petition in the month of November.
November. So you are within 120 days.
But kindly consider that. But visualize the fact, my lord. Kindly.
What do you say to this? If it is within 120 days, so then what is your submission? Whether Article Section 14 of the Limitation Act he can avail of or he cannot avail of?
Your Lordship, I will come back with decisions on the next date, Your Lordship. I will show Your Lordship judgments on this point.
Because one way of looking at it is because even if he is relegated now, then he will say no, Section 34, it cannot be, it's not within time. So he cannot be remediless. So either Section 14, whether it can be applied or not, because Section 5 for extending may not apply. Section 14
could apply.
The very recent decision of the Honorable Supreme Court.
Yes, Your Lordship.
Please check up those decisions.
Very well, Your Lordship.
appear for the petition.
Yes. Yes.
No, this is my appeal service.
Yes.
Well, here in this writ petition, my lord, I have challenged the notice. Usually I do not. You do not.
Usually you
I
do
do
not.
not. Usually
You do not, or your clients do not.
No, my client do not want to challenge the notice, but in the instant case, Lord, I have to. Lord, your lordships kindly have a look at the last annexure at page 132, annexure P17. P17, annexure 132.
Yes.
17 November notice your lordship has seen. 2025. Your lordship will see that there is a reference of writ petition number 18229 of 2025.
18229, yes.
And therefore your lordship will see that the notice under section 10(2) has been received on 12th November 2025.
10(2), where do I find that?
First line.
Yes,
a letter
yes.
received under
10(2),
section
a letter
10(2),
received.
so and so on 12/11/2025. And the 10(3) authority.
No, notice is dated.
Yes.
Notice is dated 12/11/2025. Yes.
Yes, that was received by the 10(3) authority and the fixed for hearing on 16th December 2025.
Yes.
At 12:30 p.m. In terms of this reference means WPA number so and so. Kindly see the order of the WPA number. Just before that, at page below 127. Successive notices cannot be issued. Now, this is the writ petition. May I read?
What is the harm? You appear, take that point.
Already concluded. Proceedings have already been concluded.
10(3).
Yes, 10(3), 10(4), thereafter challenge, thereafter order has been set aside, everything.
Which order has been set aside?
10(4).
10(4) order has been set
Set aside. That's why I am showing you the order.
Delegated to what stage?
10(4) proceedings, during the pendency of the, after hearing of 10(3), we challenge that order before the 10(4) authority.
Yes.
And dismissed the appeal during the stay passed by this honorable court in the proceeding.
So 10(3) order you challenge before the writ court?
Yes. No, not writ court.
So
before the 10(4) authority.
10(3) order you have challenged in an appeal under 10(4).
10(4).
Then at what stage did you come before the writ court? At what stage did you come before the writ court?
After the order passed by the 10(4) authority.
All right. So after the order passed by the 10(4), you have challenged the order of 10(4) in a writ petition.
Yes.
Then that 10(4) order was set aside.
Order was set aside.
Then it was relegated to which stage?
No, there was no relegation in this order. Only the question is that whether any further notice can be issued by the assistant engineer under 10(2) or thereafter 10(3). Because kindly see the order. I'm just reading only 2-3 pages orders. You're also
28th of August 2025.
Yes, 28th of August 2025,
Yes.
page 127. May I see? May I read just? The affidavit of service as filed on behalf of the writ petitioners is taken on record. The writ petitioner, the respondent state and its instrumentalities and the private respondents are represented by their respective counsels. By filing the instant writ petition, the writ petitioners have prayed for issuance of appropriate deeds against the respondent authorities, more specifically against the respondent 2 authority. 2 means 10(4) authority, for quashing the order dated 24th April 2025 as passed in appeal number so and so, whereby and whereunder in a proceeding under 10(4) of the West Bengal so and so, the respondent number 2 authority dismissed the appeal as prepared by the writ petitioners. It is pertinent to mention here that the writ petitioners prepared the said appeal challenging the order dated 6 August 2024 as passed by the respondent 7, who is the 10(3) authority. On careful perusal of the 2 orders dated so and so as passed in so and so by 2 separate coordinate benches of this court, it reveals that the said writ petition as filed by the present writ petitioners, the subject matter of challenge was that the order dated 6 August 2024 as passed by the respondent number 7, which was stayed till 30th April 2025. It reveals that despite such stay, the respondent number 2 authority disposed of the appeal as prepared by the appellants who are the writ petitioners before this court on so and so, ignoring the order of the stay as passed in connection with so and so, which have been annexed as so and so. At this juncture, Mr. Rao, an advocate appearing on behalf of the writ petitioners, draws attention to this court to page number so and so of the instant writ petition, being a copy of the order dated 5th May 2025 as passed by this court in so and so,
whereby and whereunder this court, while disposing of the writ petition, directed the present writ petitioners and the private respondents to participate in the proceedings under section 10(3) of the said act on a particular day. On being asked by this court, Mr. Rao submits that this court that on the day of hearing of so and so, that is on so and so, the present writ petitioners were not aware of the order under challenge dated so and so, since the same was communicated to the writ petitioners on 15 July 2025 under cover memo, which has been annexed at page so and so. It is thus submitted by Mr. Rao that when this court permitted the writ petitioners and the private respondents to approve the respondent number 7 authority for adjudication of the proceedings under section 10(3) under the said act, the impugned order under challenge dated so and so as passed by the respondent number 2 authority as per the provisions of section 4 of the said act cannot be allowed to stand. It is further submitted, Mr. Rao, that the pursuant to the direction passed by this court on so and so, in so and so, both the writ petitioners and the private respondents have already appeared before the respondent 7. Now, kindly mark this point. Both the have already appeared before the respondent number 7 for participating in the proceedings under section 10(3) of the said act, and before the respondent number 7, who is the matter 10(3) authority. Hearing under provisions of section 10(3) of the said act has already been concluded, but no final order has been passed. Such contention is, however, not opposed by the learned advocate on behalf of the private respondents. On careful consideration of the entire materials as placed before this court, and after hearing the learned advocates for the contending parties and also considering the chronology of events as discussed in the foregoing paragraphs, this court considers that the instant writ petition deserves to be allowed for the following 2 reasons. The order dated so and so was passed by the respondent to authority in an appeal under section so and so, when the operation of the impugned order before him was stayed by this honorable court in connection with so and so. This court, while disposing of the writ petition number so and so, permitted the present writ petitioners and the private respondent herein to participate in the proceeding under section 10(3) of this act before the respondent number 7 authority herein on a specified date, that is so and so. Accordingly, the instant writ petition being number so and so is hereby allowed. Consequently, the order under challenge dated so and so as passed by the respondent number 2 authority in appeal number so and so is hereby set aside. It is further ordered that all consequent action taken by the respondent authorities, including the respondent number 6, pursuant to the aforesaid order dated so and so, are also set aside. Before parting with it is, however, made clear that the disposal of the instant writ petition in favor of the writ petitioners shall not have any effect in the proceeding before the respondent number 7 authority under section 10(3) of the said act, hearing of which has been claimed to have been concluded. Liberties thereafter complete. My question is here that whether any new 10(2) proceedings can be initiated by the authority in view of this order.
This is not a 10(2). That is
Yes, is it in view of 10(2).
Please show me the order passed under section 10(3), which was challenged in 10(4).
My lord, if your lordship will.
Let him exhaust himself. Yes. Please show me the order under 10(3).
I am giving.
এটা তো এটা তো এটা তো অর্ডার এটা অ্যাপিলটা 10(4).
93.
Yes.
I'm just giving it. Your lordship kindly have a look of the annexure P9, page 93.
Page 9.
Page 93. So this, what is the date of this? Because 6/8/2024.
Yes.
Because the date is not legible.
Yeah, legible. It was not.
All right, 6/8/2024. Now, what happened to this order?
This order has been challenged up to appellate authority 10(4).
This order was challenged by the appellate authority under 10(4). So, 10(4) order was set aside.
Yes.
So this order subsists. 10(3) order subsists.
10(3) order subsists.
So no appeal. No appeal.
No, against this order, my lord, we have prepared an appeal.
That was in that.
And consequential, my lord, the orders also set aside.
Yes.
Your lordship has seen that.
So this order has not been set aside.
Not
10(3) order has not been set aside.
I have to, at the cost of repetition, I have to Consequently, the order under challenge date so and so, and all consequent actions.
Consequent is after that, not prior.
Yes.
Consequence is after 10-4.
Right.
So after 10-4, any steps, any demolition, those set aside.
Right.
So 10-3, what is this? 10-3 order still remains.
Yes.
10-4 order set aside.
Right.
Have you challenged 10-3 order?
No, the notice, no, I am here.
Right. I'm setting aside. Have you challenged this 10-3?
But till date, I am not. Or I have to take instruction whether they have challenged or not. But this notice cannot sustain.
I'm directing because it's time barred. I'm directing implementation of this order. I will set aside everything, notice everything. No hearing, this order will be implemented.
But that I don't know whether they have any appeal or not. That I have to check up. That I have
appeal
to check
is
up.
10-4.
Appeal in 10-4.
We show that
Yes.
10-4 appeal or this order was passed in 2024, till not now challenged. 10-4 orders have been set aside. After that, if you have not challenged, everything gone, this order will be implemented.
But that I have to check up whether any appeal, further appeal has been filed challenging this or not. That I have to check it up. But notice cannot stand by this way. This notice cannot sustain.
The order also cannot go.
That
order cannot go.
But I am not.
According to you, you have said this order still remains unchallenged.
Unchallenged, my lord.
Till now, challenge set aside. Thereafter, nothing.
Nothing. That for that, not have to take instruction whether they are
Instructions have come.
paper and appeal or
Please
not.
take instructions and come. What happened to this order?
Right. Right. Absolutely right. Yes, that's right. That's right.
Yes. What is your submission?
My lord, actually, as per the, my lord, this order, my lord, the 10-4 order has been set aside for
10-4 order has been set aside
for
What
a
happened to
technical
the
ground.
Order under 10-3
My lord,
has been set
my
aside.
lord,
Technical merit.
my lord.
So 10-4 order is not here.
So, my lord,
10-3 order stands or
is
does not
subsisting.
stand.
Is subsisting. 10-3 order is subsisting.
If the 10-3 order is subsisting, how can a fresh notice under 10-3 be passed, be issued?
My lord, I am the private respondent. My lord, the state is.
Oh. That is why I gave you the first right to make his submission before calling upon Mr. De. So you have no answer. All right. Yes, Mr. De.
Now, my lord, if your lordship, page 130, my lord.
1-3.
My lord, they filed the appeal.
Yes.
They filed the writ petition, my lord. That is page 127. That is 18229 up to 2025. In that, my lord, he challenged this. That is by filing a challenge official. That is
Mr.
the
De,
dated.
please give me a minute. Please give me 1
He
minute.
challenged this, my lord, in 10-4, whereupon a proceeding under section 10-4 of the West Bengal Highways Act, the respondent authority dismissed the appeal as prepared by the writ petitioner. My lord, that petitioner, my lord, mentioned here the writ petitioner referred to the appeal challenging the order dated ATO.
Yes.
Now, my lord, that on careful consideration of the ATO and ATO, then 6-4 is passed, authority which is still stayed till April ATO. My lord, there is a stay order. In spite of stay order, my lord, that order was
For
passed.
that it was set aside.
For that is that order. After that, at this juncture, my lord, that the learned advocate of that is paragraph 5, my lord, draws attention to the court that ATO instant writ petition being a copy of the order dated ATO passed in WPA number 20204 of ATO, whereunder the court, while disposing of the said writ petition, directing the present writ petitioner private respondent to participate in the proceeding under section 10(3) of the said act on a particular date. On being asked by this court, Mr. Raut submits before this court that on that day hearing of the ATO, that he is on ATO, the present writ petitioner were not aware of the order challenge and ATO, since the same was communicated to the writ petitioner on 15/7. My lord, they said that under cover of memo number ATO, it is submitted by Mr. Raut that this court permitted the writ petitioner and the private respondent to approach the respondent number 3. My lord, that is authority for adjudication of the proceeding under section 10(3) under the said act. The impugn order under challenge of by that is that is the order dated 10/4 challenge. As per provision of 10/4 of the said act, it is further submitted the pursuant to the direction passed by this court on ATO. In ATO, both the writ petitions and the private respondent have already appeared before this court for 7 for participating in proceeding under section 10(3) of the act, and before the respondent number 7 authority under the provision of 10(3) of the said act has already been concluded, but no final order has been passed, my lord. Such contention is, however, not opposed by the learned advocate on careful consideration of the entire materials of records discussed in ATO, my lord, that is allowed for the ATO. The order dated was passed by the respondent number 2 authority in an appeal under section 10(4) of the said act, when it was stayed. And another, my lord, another part, that is 10(3). This court, while disposing of ATO, permitted the present writ petitioners and the private respondent taken herein to participate in proceeding under section 10(3) of the said act before the respondent number 7 authority herein on a specified date or Punaropach, that is 25. Accordingly, recent writ petition, that is, my lord, that writ petition is disposed of directing. Consequently, the order under challenge dated 10(4) as passed by the respondent number 1, ATO is hereby set aside. 10(4) was set aside, my lord. Now it is further ordered that all consequent action of the ATO respondent authority, including the respondent was seek pursuant to the aforesaid order dated ATO, are also set aside.
Yes.
Before parting with, it is however made clear that the disposal of the instant writ petition in favor of the writ petitioner shall not have any effect in the proceeding.
Yes.
Before the respondent number 3, my lord.
Yes.
Authority under section 10(3) of the said hearing, of which has been claimed to have been concluded. Liberty is given to the learned advocate on record to communicate the server copy of the order of to ATO respondent number 6 authority directed are to be ATO. This is the position of law, my lord.
Mr. Raut.
Yes.
On 28th of August 2025,
right,
you have made a submission that hearing under section 10(3) was concluded, but no final order has been passed.
Absolutely.
So what is this order in 1993? That was 6th of August 2024.
That was the earlier order which was set aside by the.
Show me. So you said this order has not been set aside.
Oh yes, that order was has been set aside, but thereafter, in terms of the High Court.
Show me by which order this was set aside.
Lord, your lordship,
and your own submission was that you participated in a hearing.
Yes.
And no order has been passed.
Yes.
That was as far back as on 28th of August 2025.
Your lordship kindly
What
come to
after 28th of August.
Lord, your lordships kindly have a look of the page 117,
yes,
wherein the 10(4) authority has affirmed the order of 6 August 2024.
Mr. Raut, what is the position in law if an order is affirmed by the appellate authority and only the appellate authority's order is set aside? What is the effect of that order?
Effect is that, my lord, if the authority
the original authority's order also goes.
Yes, in view of the yes, in view of the order.
If that is your submission, then 6th of August 2024 goes. So 10(3) notice was validly.
No, Lord.
Then 10(3) order has to be passed.
10(3) order has to be passed, but no notice can be given because hearing concluded. My submission is that.
When hearing was concluded?
I have claimed before 28th August.
When? Please give me this specific
date.
Lord,
I am showing the notice. Lord, I am showing the notice. I am showing the notice.
So,
yes,
so
I am showing.
Want to participate in a further hearing?
Not required at all.
All right. So I will.
Lord, your lordship can be.
You do not intend to participate in a hearing.
Lord, your lordship kindly. I am giving you the notice. Lord, the 14th May and 31st July.
If you say, by virtue of the setting aside of the 10(4) order, 10(3) order also goes.
Yes.
Then this notice was valid. Because if they want, you are free whether to appear or not to appear.
But
if the authority, after setting aside, feels that a further opportunity, or you will say, yes, after that we wanted to submit something, I will record your submission. You do not wish to make any further submission. If they want, they will hear and pass an order.
Only one submission I have.
And if you say no, that 6th of August 2024 remains, then if that order stands, you have not challenged, gone.
So
please take instructions and
6 August order gone. According to me, legal position is that 6th
All right.
August order gone
So there are
in
two
view of
ways.
the order passed by the appellate authority and subsequently set aside by this honorable court. That gone.
So if that is gone, encroachment will remain.
No, this is not a case of encroachment. What has happened here?
No,
Here
this
the
order.
petitioners.
No,
No, I am not on merits, though I am not on merits.
Mr. Raut, from which stage it is to, if a proceeding, some orders has been set aside, but not the proceeding.
No, I am
So
not
from
saying
which
that.
stage? So please enlighten this court from which stage
Right.
this proceeding will continue.
Lord, here,
Lord, 1,
Lord,
10-2, 10-3,
no,
or 10-4.
Lord, so far this proceeding, this matter is
On the
concerned.
facts of this case,
So far this,
from which stage it will proceed?
yes, Lord, so far this case is concerned, only the respondent number, the authority of the 10-3 authority is required to pass the order, nothing else.
All right.
No more.
So
Nothing
hearing
else.
is concluded.
And Lord, hearing is concluded. I'm
All right. So
the notice.
Mr.
I'm showing you a notice.
Mr. Raut, you have taken instruction. You do not want to make any submissions.
No, not required at all.
So you have already made your submission.
Yes.
So if the
Yes,
private respondents make, they will.
Then they can do that.
All right. So I will.
But 10-2.
But please file an affidavit to that effect that you have already made your submissions under 10-3. You do not wish to make any further submission. This has to come on affidavit.
Very well.
This has to come on affidavit.
Yes.
And what is the effect of 10-3 order? Please file a supplementary affidavit. After that, you will come and say, no, they have submitted something behind our back. We were not present. That I will not allow.
If I submit that, no, that will goes blow against me in respect of this order.
Mr. Raut, they can make submissions.
Yeah,
so if you want to
but
control,
they have also considered that the hearing has been concluded.
Mr. Raut, in many cases in which hearing has been concluded, if the authority feels but no order has been passed,
yes,
cannot a further hearing cannot be taken.
Right.
So that's
No,
an
it
opportunity.
can be taken.
It's your whether to accept it or not.
But this proceeding has initiated as trying to initiate it, Milord, 10-2.
For your benefit, because 10-3, according to
No,
you,
10-2. It starts 10-2. Again 10-2, 10-3, 10-4. Kindly see the notice.
No 10.
And 10-2, 12, 11.
10-3 started. That is the 10-3.
10-2, 12, 11, 25.
No. Mr. Raut, the very initiation of 10-3 proceedings is 10-2 order.
10-2 order.
So they have referred to that. They have not issued a notice.
And when it was issued, 12 November 2025.
Yes.
It cannot be. According to me, Milord, with respect to submission people also, it cannot be on 12 November 2025. Because the hearing has already been concluded in July 2025.
For what?
By 10-3 authority.
Mr. Raut, after that 10-4 order, 10-4
No, not before that. Not after that. In August, Milord, there was an order by the 10-3 authority.
Till 28th of August 2025, no order was passed. Under 10-3.
No. Right. Yes. No order was passed.
No order was passed. So they want a hearing under 10-3. They are fixed on 16th of December. But
in terms of the 10-2 issued on 12th November.
Show me the notice under 10-2 dated 12th of November 2025.
I am showing you notice. This is absolutely a wrong thing which they have not. They have issued the notice. Kindly have a look of the page 125.
Yes.
125.
Yes.
May 14th May.
Yes.
14th May. This notice, the earlier notice was issued for participating and original documents. Yes. We appear there. Both the parties appear there. Hearing concluded in terms of this notice. This notice was issued pursuant to the notice issued under 10-2 earlier. And thereafter, again, another notice was issued for final hearing.
This is the 14th of May 2025. After that, 10-4 order has been set aside. In 28th of August 2025. Subsequent to the passing of the order by this court, this notice of hearing has been issued. So why are you afraid of appearing before that authorities? You can make all submissions. You are given an opportunity of hearing. You do not want to avail of that.
No, that is not the issue, my lord. Here the issue is that, my lord, the successive notices, my lord, cannot be issued by the concerned authority.
Even for your benefit.
No.
Even for your benefit.
This is against my benefit.
Why?
Because
you don't want to contest.
No, I have already here concluded the hearing.
Raul, even if I accept the 10-3 order has gone, 10-2 notice is operating against you. You cannot say it is against you. So hearing is to protect your right.
10 to the earlier notice, my lord, can be, but the 12th November notice cannot be stand. This is a fresh notice they have issued.
All right. You take instructions whether
Very well. Very well.
You want to participate or not. I will allow them. I will direct them to pass an orders. I will record your specific instructions that you do not want to avail of an opportunity of hearing. Please take specific instructions with regard to that, and please prepare a list of dates.
Very good.
Because there are many orders.
Many orders, many writ petitions were also
many
filed.
writ petitions, many
By-
orders
by the
passed.
private respondents, yes.
So do one thing, prepare a list of dates, annex the orders of those writ petitions, nothing more. The others are not required. Only the
Orders.
of those,
Orders.
all these writ petitions, please place those
Orders.
orders in a bunch. Please produce, give copies. When, how soon can you take instructions?
Lord, 1 week is required.
All right.
Because
After
your
two.
after two, well, Lordship will speak or not?
What do you want?
Let's see.
All of you want?
Yes, yes.
The bar wants. All right. Yes.
My lord, before my lord rises.
Matter is, my innocuous prayer is there.
What is the innocuous prayer?
My lord, my innocuous prayer is that, my lord, I am the owner of the land, which is adjacent to the State Highways Act. Lord, where, my lord, the Sagar police station, my lord, is enclosing, has enclosed, not enclosing, has enclosed a portion
Police
of the
station
land.
is enclosed?
Yes. My lord, because of that reason, I want, my lord,
So you
for
want to
direction
protect
upon
one
the-
encroachment and remove another. Two things cannot dwell at the same
No,
time.
no. That is another matter. This is
I
another
want
matter.
to protect encroachment. I will not allow
No,
you
no,
to
no.
remove
What I want? I want, my lord, for a direction upon the concerned block land and animal officer to demarcate the land and.
Who is
dispose
appearing?
the- Yes.
Today you are appearing.
Yes, my lord.
Yes.
So
what is
kindly see
the-
my.
My lord, I
Look,
say,
I'll see my
submit
petition.
that his petition is not maintainable.
Huh? Is not maintainable. Why?
Yes, my lord.
Is not maintainable. Then
Yes.
next day.
Huh?
Then next day he says it's not maintainable.
Yes,
Then yes, to argue fast. How it is not
That is why.
maintainable. Very good.
He do
Very
not
good,
want
very
to
good.
come after 2 p.m.
My lord,
Next
may
Monday.
we, at the risk of being
Monday.
reprimanded, my lord, I'm mentioning item number 81. There's some urgency, lordship,
81.
of today's list, my lord. My lord, is that restaurant matter, chai break. My lord, some precedence may be given, my lord.
Monday.
Monday, I shall. Deeply obliged, my lord.
I'm grateful to your lordship.
Yes, Mr. Mitro.
No.
All of you do not want.
That's
That's
submission
made by the
my lord যাবে
senior
না 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 my lord যাবে হ্যাঁ সবাই যাবে
my lord যাবে সার্ভিস সার্কিট বেঞ্চ
জলপাইগুড়ি আছে হ্যাঁ
So no.
Your Lordship, item 19, my lord, I am also having some urgency because that matter, my lord.
আর 19 হয়ে যাবে সোমবার
Whether, my lord, 1919, that, my lord, West Bengal Highway Acts, the court had directed to proceed with regard, my lord, following the proceeding of West Bengal Highway Acts. They have initiated proceeding. Malot under the Malot eviction, public eviction, that particular.
that matter.
Yes.
That matter.
They are Malot pressing hard.
Time. ওটা করে
Pay-
দিন।
press-
Since an order has been passed under the 1962 Act, please, I'm not inclined to take up.
Malot item 19, Malot. On the earlier occasion, Malot, because
Yes,
the
yes,
court
I
is
want
specific.
I have adjourned that matter to seek clarification. I've sought for clarification because it's under the 1962 Act. I cannot take up. Please make submissions there that I could not have been initiated. কোথায় গেল ফাইলটা দিন? You have your copy, please.
Malot, yes, I am having.
পেয়েছেন?
Sorry. Because they are pressing hard, Malot, to demolish.
No, all right. Since the order
Thank you. Much honored, sir. Much honored.